Income tax case law. Subject: assessment cannot be reopened for change of opinion. High Court of Bombay judgment as follows. This video is sponsored by PracticeGuru. Facts of the case. The petitioner, Suminter Organic and Fair Trade Cotton Ginning Mill Private Limited, issued shares at a premium during the assessment year 2015-16. The case of the assessee was selected for scrutiny by the assessing officer due to the substantial share premium received during the relevant assessment year. During the scrutiny assessment proceedings, the assessee submitted that the fair value of the shares issued at a premium was determined based on a valuation report obtained from a CA. The valuation report used the DCF method to determine the fair value. The assessing officer considered the submissions made by the assessee and passed the assessment order, accepting the valuation of shares based on the DCF method. Subsequently, the assessing officer issued a notice for reopening the assessment, claiming that the amount received as share premium was not valued correctly as per Rule 11 UARW Section 56, 2 WIB of the Income Tax Act. Before moving ahead, please understand that tax litigation is going to be a big revenue-generating practice. To take advantage of it, start studying case laws from now with Court-wise. Subscribe to channel now. Let's now move ahead. Decision of the court. The court held that the reopening of the assessment by the assessing officer was not justified. It ruled that there was no failure on the part of the assessee to disclose fully and truly material facts during the original assessment proceedings. The court noted that the issue of the valuation of shares and the premium received had been raised by the assessing officer during the original assessment proceedings, and the assessee had provided responses and a valuation report to support their position. The court emphasized that the assessing officer's power to reopen an assessment should not be used as a means of reviewing the assessment or as a change of opinion. It cited the Supreme Court's decision in CIT v. Kelvinator of India Limited to support this principle. The court also highlighted that Rule 11 UA of the income tax rules provided the assessee with the option to determine the fair market value of unquoted equity shares using the DCF method, as certified by a CA. Therefore, the assessee's choice of valuation method was valid. As a result, the court set aside the notice for reopening the assessment and disposed of the petition in favor of the assessee, finding that there was no valid reason to reopen the assessment based on the facts and circumstances of the case. Parties: Suminter Organic and Fair Trade Cotton Ginning Mill Private Limited versus Deputy Commissioner of Income Tax. Citation: WRIT Petition number 2179 of 2022. If you like the case law summary, please like and share it. If you want to read the case law, please refer the description of the video. If you want to grow your tax practice like 2000 other tax professionals, visit our website www.practiceguru.pro. Download our app One-Click Branding, which is available on both Apple App Store and Google Play Store, or WhatsApp us on 9136667325. Also click on the link to watch next video and don't forget to subscribe to our channel.